Thank you, everybody. This is the panel that we've all been waiting for, which is why we put it last, so that more of you stay. It's our Enforcers Roundtable, and it's actually on a topic that is fundamental to the very business models of so many companies around the world. We're going to be talking about extraterritorial antitrust regulation of antitrust licensing. I have a number of people that you've already seen. We're going to start maybe in opposite order this time to show you that I, too, can be innovative. And in this capacity, I'll just remind everyone, he's speaking in his personal capacity, not an official JFTC capacity. Thank you for mentioning that.
Right. Now, the first part of this these slides is about the guidelines, and you have already heard about that. Now, I'm going to talk about the two IP-related cases in Japan. And actually, but you will see that the first case, Apple Samsung, is a case of the civil litigation, and not the action by the JFTC. The second one also started with civil litigation. We did take an action, but civil litigation was also involved. So you will see that there are not many IP-related cases in Japan. In the morning, I did talk about the pachinko machine patent cases, but that was 20 years ago, and that was rather exceptional in that sense. And since then, we do not have many IP-related cases. So first of all, I want to make one comment to Danny's discussion in the previous session. You talked about something like Asian model and compared to the European model, American model, but I don't think there's any Asian model. And listening to the stories in Taiwan and India, I thought that the situation there are quite different from what we are doing in Japan. So talking about Asian model, I thought is a very interesting to do. Now, and you will also see that these two cases involve all foreign companies. So, so in that sense, whether there's any discussion of extraterritorial things relevant to IP or not, that's, I think, a very difficult question to say. But you will see that actually in those cases, it was the foreign companies that were involved. And, of course, we are concerned about the effects on Japanese consumers and Japanese users. Now, the first thing is the Apple Samsung case. As I said, this is a civil case, and this is probably a part of the worldwide Apple Samsung disputes in IP. But the first Samsung sued Apple, saying that the Apple is violating Samsung's patents, and the Samsung sought injunction and also damages. And then Apple countersued in that saying that what Samsung is doing is the abuse of right. The case was a heated one, and then finally, the decision was made by the IP High Court of Japan. In Japan, there's a IP section, a specialized section within the High Court of Japan, and that is usually called IP High Court. Now, here is the decision. Sorry, I should have that. Here is the decision by the IP High Court. On injunction, the decision said that the exercise of a right to demand an injunction based on the F-RAND encumbered patent is an abuse of rights, according to the civil code, if the other party could prove that it was willing to take a license under the F-RAND conditions. And on damages, it said that the claim for damages filed by Samsung constitute the absolute use of right to the extent exceeding the amount of the efferent royalty, but does not to the extent of the amount not exceeding the efferent royalty. So, and therefore, the court has to decide what exactly is the amount of the efferent royalty. And indeed, they did calculate the amount of the efferent royalty based on a certain formula. By the way, I should say that this case was quite exceptional in the sense also that the High Court asked for the public opinions from the general public. So many scholars, many companies, and so forth did submit opinions. And the court actually looked at those comments, and they did also have the hearings from those other companies and so forth. And based on those kind of deliberate examination, the court calculated the efferent royalty to be just this much. You see that that's something like $100,000, which is obviously far lower than what the Samsung demanded. And so the court ordered Apple to pay this amount, but they did not accept Samsung's demand for further damages. Okay. I should also mention that when Apple countersued Samsung, the Apple also mentioned about the Anti-Monopoly Act. They were arguing that what Samsung is doing is violating the Anti-Monopoly Act. There is a clause on the prohibition of abuse of superior bargaining position. And Apple argued that Samsung behavior violates this. But the court actually said, mostly talked about this abuse of rights in terms of the civil code, and just mention just one sentence or two about the Anti-Monopoly Act. But the only thing that the court said about the Anti-Monopoly Act is that similar to that, as long as it's not beyond the efferent term, it's not abuse. Okay, beyond that, it can be the abuse in terms of the Anti-Monopoly Act as well. But up to that level, it is not in violation of the Anti-Monopoly Act. So basically the same thing about the Civil Code and the Anti-Monopoly Act. Now, the second case I want to talk about is what's called the One Blue case. Perhaps I had better show this picture. There's this patent pool called One Blue. This is the headquarters in New York. Okay. And it's a patent pool for Blu-ray discs, BD Blu-ray discs. Okay. And then here the manufacturer of the discs called Imation. This is the headquarters is in the United States. And there's a Japanese subsidiary called Imation Japan. In fact, Imation entered into Japan by acquiring a Japanese company called TDK, acquiring the disc business of the TDK. So therefore, they were selling, at least in Japan, they were selling under the brand name of TDK. Okay. Now, the One Blues, the Imation said that the license fee is too expensive. And so they refused to pay. And One Blue was saying that that is against the they are violating the patent laws. And so what they did was the following. The Immersions was selling the Blu-ray discs through many retailers. And there are major 3 big retailers. Okay? So, and then the Wambru sent a notice to those 3 big retailers saying that those retailers are selling, they are against the patent that held by this Wambru. And therefore, the Wambru said that we have a right to seek injunction to these retailers, not to the manufacturer, but to the retailers. Okay? So that is the basic idea of this case. And then we see that the Immersion filed a lawsuit in 2013, and the Tokyo District Court ruled that Wambru was not allowed to exercise the right to seek such an injunction because it constitutes an abuse of rights. In this decision, in essence, the court accepted that the Immersion is a willing licensee. Okay? As I said in the morning, to decide whether the license is actually a willing license or not is a very, very difficult, probably the most difficult part of these cases. But in here, the district court said that it is an abuse of rights, and implying that the Immersion is considered to be a willing licensee. And then, therefore, in last year, JFTC decided Wambru unjustly interfered with the transaction between Immersion and the retailers, which is the definition unfair trade practice, that is interference with the competitors' transactions, and therefore is a violation of Article 19. Okay. As I mentioned in the morning, the guidelines said that if they take such an action against willing licenses, that can cause the violation of the Anti-Monopoly Act. So in this case, as the court have already recognized that it is a willing licensee, so in that sense, it was easier for us to say that, to apply the guideline to this case. Okay, and in fact, I should also mention that in this case, the license fee charged by the Wambru, okay, that was decided as a certain dollar per disc. Okay, the amount, not the percentage of the sales. It says it's a certain, I forgot the exact number, but a certain dollar per disc. Okay, and my feeling is that in the beginning, when the patent pool was set up, that was when the standard for the Blu-ray disc was actually set and the commercialization started. At that time, that amount of dollar, that was probably a very reasonable percentage of the price of the disc. But then afterward, the price of the disc has gone down very rapidly. And therefore, at the moment of this dispute, in terms of percentage, that was very large. Even though in terms of the dollar, it may not be so. So that is, and that is what the Immersion has been arguing. The license fee is too expensive, and we require much lower license fee. And then Wambru was saying that, well, we have to follow FRANT, non-discriminatory. And we are asking the same license fee to everyone. So we have to follow that. And so they were just discussing on that. So, there was not much way to agree with each other in that sense. As I said, under that kind of situation, I believe that it must have been very, very difficult to, say whether it's a willing licensee or not. But thanks to us in a sense, the court has said that it's a willing licensee. So as I said, the willing licensee issue is a very difficult one to decide. Now, these are, as I said, that there are not many other cases in Japan involving IP. Well, of course, there are, like in China, in many of the, at least several of the merger cases, there are cases when the IP was, related issue was raised, particularly in designing remedies. But in terms of the monopolization or the unfair trade practices, the cases related to IP is not many. So I repeat that there's not any Asian model for that, I think, quite different from other Asian countries, I think. So thank you very much.
Thank you. So next we're going to hear from Roger. It's a great pleasure to hear from the ACCC, one of the great competition authorities of the world. And Roger also has a distinguished career in private practice before moving to the government side. So you've seen it all before on various sides of these sorts of debates.
Yeah, I might stay here if that's all right.
It's only, what, 14 hours time difference from...
I think it's more like 19, I think.
Okay.
Yeah. But that makes it easier because it's only like 5 hours ahead of where I should be. So, yeah.
19 and a half.
Yeah, okay. Well, Adelaide's always different. Okay, thank you very much. I appreciate the opportunity of being here. So thank you to the USC Gould School of Law for the invitation. I thought I might start by just explaining a little bit about the ACCC and our competition laws. So first, I think, for those of you who are not familiar with Australia, I mean, it's a big, it's a big country, probably just a little bit smaller than the continental United States, but we only have a small population, about 25 million. And so whilst many of you might imagine kangaroos in the outback or turtles on the Great Barrier Reef, the reality for most Australians is actually big cities. Most of us live in big cities, so such as Sydney and Melbourne that are featured up on the slide, which each have a population of about 4.5 million. The ACCC is a federal body. We're an independent statutory corporation, and we have offices in each of the 6 states and 2 mainland territories of Australia. We have responsibility for both competition and consumer law, as our name suggests, and we have quite a few responsibilities, and I won't go through all those on the board there, but we also do regulation as well as enforce competition and consumer laws, and we do these days a lot of market studies or inquiries. I think one of the aspects of our law on the competition side is that most of our provisions, apart from cartels and resale price maintenance, which are per se contraventions, most of the other competition provisions actually involve a substantial lessening of competition test. And like a number of agencies around the world, we don't have any power to enforce the law ourselves. We have to go to the Federal Court of Australia if we wish to enforce the competition provisions. What we have as a competition policy is that we don't regard it as a contravention of the law to have market power, and so in relation to IP rights, for example, even where they do confer a degree of market power upon the owner of those rights, that in itself is not obviously regarded as a breach of our law. And what we concentrate upon is either the acquisition of market power through mergers or acquisitions. So our Section 50, for example, prohibits acquisitions of shares or assets where there's likely to be a substantial lessening of competition in a market. And we rely obviously upon our misuse of market power provision, which is in Section 46 of the Competition and Consumer Act. Excitingly for us, just last Monday, Section 46 was amended and came into operation on Monday of this week, to make it conform more closely with the other provisions and to introduce a substantial lessening of competition test into that provision. One of the cases that I was going to refer to is the Pfizer case, because it's one of the few, I think, that really involves IP. And it's still before the courts, but we did take action a few years ago against Pfizer, alleging that it had sought to leverage the market power that it had as a result of its patent of the Lipitor drug to actually effectively block entry by generic manufacturers for a period after the patent expired. The intention, I think, of Pfizer was really to get a 12-month blockage of competitors coming in. Its strategy, I don't think, was executed as well as it had been hoped, and they probably got about a 5-month advantage. But we took action alleging a breach of the misuse of market power provision, section 46. We also alleged a breach of our exclusive dealing provision as a result of the nature of the offers that they made. We were unsuccessful at first instance, but we have appealed, and we're still waiting for the appeal judgment to come out. But that was an interesting case, and one that we're hopeful of getting a satisfactory result from the appeal. In terms of other provisions, obviously we've got a general prohibition against making or giving effect to contracts, arrangements or understandings, again with a substantial lessening of competition test. That provision was enhanced as from last Monday to extend to the concerted practices. So it prohibits concerted practices now where there's a purpose or effect of substantially lessening competition. One of the features of our law up till now, and this law, whilst the Act we currently operate under is the Competition and Consumer Act 2010, it's actually based upon the Trade Practices Act of 1974. So the Commission has effectively operated since 1974. It used to be called the Trade Practices Commission, but the provision that we do have is in relation to IP, and I think it's the only provision in the Act that really relates to IP, is an exception in section 51, subsection 3, which does give a limited exception for conditions contained in IP licences or assignments, where the condition, or at least to the extent that the condition relates to the products or the subject matter of the IP rights. There's been a fair bit of debate as to how effective that provision is. There's also been a number of governmental inquiries, I think 7 or so, where the inquiries have recommended the repeal of that provision. And finally, just in the last few months, the government has accepted the recommendation and they're proposing to repeal it. Unfortunately, their decision came too late to be included in the amendments that went through recently, but hopefully it will be repealed fairly shortly, and that's the reason why I haven't bothered to put it up on the slide, because hopefully it won't be law going forward. But as I said, there's been real debate as to how effective it's been and whether that protection has actually been required. And both in my practice, whilst we were comforted by the fact that we could argue the provision, we were never all that confident, quite frankly, as to how effective the argument would be. And it's also consistent, as many of these inquiries have pointed out, that to treat IP rights as really just like other property rights, it's not appropriate to have an exception for IP when you don't have the exception for other property rights. So, as I say, I'll look forward to the repeal of that provision shortly. I was going to not go there yet. In terms of Other provisions, one of the features of our consumer protection laws is a very simple provision that we've had actually since 1974, and it's one of the few sections that hasn't actually been amended in the meantime, is a very simple prohibition of misleading or deceptive conduct, or conduct that's likely to mislead or deceive. And that provision has actually been litigated extensively, and including as between private parties in relation to alleged infringements of intellectual property rights. So, you know, often in trademark infringement matters, there's one of the claims is that the infringer has misled or deceived by misusing the trademark or whatever it might be. And that is a provision that we also litigate, but we normally litigate in the context of consumer protection. And I thought I'd just mention an example of a case that we did run because it does have an extraterritorial aspect to it. And that was a case we took last year against Valve Corporation, which is a US corporation that sells computer software for games, and it's got a large number of customers in Australia, but it doesn't have an office nor any employees in Australia. And we took action alleging that it had failed to honour our consumer protection laws by failing to provide for refunds where the goods were faulty. And their defence was A, that they weren't carrying on business in Australia, B, that their contracts were subject to the laws of a state of the United States, and therefore they, for a number of reasons, were not liable to comply with the Australian consumer law. We were successful in that case, although they have appealed against that, and they have also appealed against the penalty in that matter. But we did succeed in establishing that they were carrying on business in Australia, and that is one of the aspects which, by which we can actually seek to apply our laws to conduct overseas. So we, in terms of extraterritoriality, we do need to show some nexus to Australia, either that an Australian corporation or person was involved in the conduct, or that the foreign corporation carries on business in Australia. There are a couple of exceptions. I think the exclusive dealing provisions, for example, can be applied without that nexus, as long as you can show that they've got some effect on a market in Australia. Obviously, we are normally only interested where there is an effect on a market in Australia, so that aspect is not one that troubles us. But it obviously, in most cases where conduct does have an effect in Australia, we normally find that there's a corporation that is either Australian or is carrying on business in Australia. So I think in most cases where we're concerned by agreements overseas or conduct overseas, we can find jurisdiction, but it's not always the case. And I thought I'd just, by way of interest, and I'm happy to cover any other matters that people might have questions about, and these slides, the last couple of slides are probably off topic a little bit, but I've included them because I think that our Productivity Commission has been responsible for some very interesting reports recently, and also some pretty clear thinking in terms of a couple of aspects which relate either directly or indirectly to intellectual property. I mean, in data, there's a lot of reform being talked about in Australia in terms of looking at access to data, and the Productivity Commission has recommended that you don't focus upon trying to limit a corporation's use of data, but you focus really upon ensuring that in the case of consumer data, that the consumers have access to that data, and not just access, but access in a usable form. So, for example, ensuring that if a consumer wants their electricity retail data provided to another electricity supplier in order to get a competing quote, for example, then the corporation that has the data should be under some obligation to actually transmit the relevant data in a usable form to whomever the consumer wishes it to be sent to. And that's, there's various examples that have been put forward in terms of medical data, where doctors claim the rights to the medical data, and patients should have the right to have that data transmitted to a hospital, for example. And we have been involved in, for example, recommending that in relation to servicing data for automobiles, that actually be made available to repairers who aren't necessarily affiliated with the manufacturer. So there's some interesting developments in those sorts of areas. And then more relevantly to this conference, the Productivity Commission has recently issued another report in relation to intellectual property, and has applied some principles by which they suggest that we review our laws in respect of intellectual property rights, and also in terms of some of the processes by which disputes can be resolved. And I think that's also a direction that we have supported. So we have been quite active in actually making submissions to some of these inquiries, and also supporting some of the recommendations. And one of those recommendations, which I suppose is relevant to something that was raised a little bit earlier, is that the Productivity Commission and ourselves have argued that Australia should take a more cautious approach to making concessions in trade agreements in relation to IP rights. There seem to be quite often the concessions that are made in order to achieve other objectives, and without necessarily analysing the benefits and the detriments of those concessions. And again, it's not saying that the concessions shouldn't be made. It's more a question of saying, well, are we confident that we've actually analysed the benefits and the detriments of those things? So unless there's anything else, I might leave it there, and I'm happy to take questions. Thank you.
Thank you. Oh, we have a question, but that's your question. But before we get there, actually, there's something else I think you might want to explain about the Australian system. It's simply unique. There are more words to the Australian Competition Act than I'm told. Maybe the Vietnamese Act comes close, but like by magnitudes longer than any other act, minus New Zealand, which is maybe a half to a third of yours, and even that's a bit long. But you guys are much longer than any other agency in the world. Why is that?
There's no good explanation for that. It's one of the reasons why I like that consumer protection provision that I mentioned about misleading and deceptive conduct. Is about 2.5 lines long. It's been used in many, probably hundreds of cases over the years, and it's worked very well and has been capable of applying to all sorts of industries with all sorts of technological developments over the last 40 years since it was introduced. And yet most of our other provisions, as Danny's indicating, are very long, complex sections which only cause us problems when we get to court, because the court weighs up every word and allows for arguments and so forth. And it's a very unfortunate style of drafting that has been adopted.
Okay, so
sorry, there was one other point I should have made, and some of the words actually do extend to allowing for authorisations and notifications. So the other process that we've got in Australia is that you can actually seek an exemption from the competition provisions, normally on the basis of a net public benefit for the conduct. And that's probably more important, because we tend not to take full account of efficiencies in terms of assessing lessening of competition. And so if you really do believe that your anti-competitive conduct is justified by public benefits, then you can actually apply through this authorisation process for an exemption. The amendments that came into operation on Monday also allow for you to get the exemption if your conduct will not breach the Act, so that will add to our workload probably. Sorry, thanks, Danny.
Question.
Yeah, I think it's very commendable as an economist that actually that is the goal economically. But here, I had a question about the American gaming company with the Australian clients. What's going to be the enforcement mechanism if they don't have any presence, a physical presence? Are you going to go after the consumers?
Well, we have got various international arrangements to actually enforce judgments. It's not necessarily that easy, but it's possible. I think in terms of that step, we'll cross that bridge when we get to it. It's more a question of ensuring in the future that they actually do honour their consumer protection commitments, and they have already amended their contracts to take into account Australian law. I think most of these companies sort of think that Australia is only like 2% of world commerce, and therefore if they've got a global agreement, they don't need to worry about Australia. Well, we differ.
Dina.
Two questions. One for Commissioner Odagiri and for Australian speaker. The Japanese Apple Samsung case, was that a patent case or a competition case? And, well, maybe I'll ask you a second question afterwards. Go ahead.
No, it's not a competition case.
Okay.
Yeah.
So it was a patent.
As I said, there's some mentioning about the Anti-Competition Act in there, but that is a very small part of the whole decision.
Thank you. And for Australia, it's interesting. So it seems the whole standard for unilateral conduct has changed in Australia this week. Is that right? And what was the standard before?
The standard before was that we had to show that a company had taken advantage of its market power, which in itself was a problem, and we had to show that it was for the purpose of either damaging a competitor or deterring competitive conduct. And so we argued that there were two problems with that provision. One was that the way in which the courts had interpreted taking advantage was that there were some decisions where the court said that if a company without market power could engage in the same conduct or the same type of conduct, then clearly the company with market power wasn't taking advantage of its market power because it could have engaged in that conduct without having market power. That sort of misses the point a little bit as to, that whilst the conduct might be similar, the effects of the conduct will be quite different if you've got substantial market power than if you don't. And then the other aspect of having a purpose of damaging a competitor or deterring competitive conduct was really directed at the wrong principle. I mean, the normal principle is that we're out to protect competition, the process of competition, not out to protect competitors. And so the previous misuse of market power provision was really directed at actually looking at whether the conduct was aimed at damaging a competitor. That's the way it's been interpreted. I don't necessarily think that that is the case. The substantial lessening of competition test is a difficult one, and there'll be some cases where it's easier for us to bring the case, and there'll be other cases where it'll be more difficult. For example, previously we could bring action where a company took some action against a competitor which might have been short-lived. It may have been a relatively small competitor, and that may still have triggered the old misuse of market power provision. With the new provision, we'd have to show that the conduct either had the purpose or the likely effect of substantially lessening competition in the market more generally. So it'll, there'll be pros and cons of the new provision.
In the interest of time, we're going to move on to our final two speakers. But I do want to just note that Australia is unique and interesting in many ways. During the cocktail hour, I would advise those interested to talk to Roger about something called the hot tub, which is actually really fascinating. It's not the hot tub that you guys think about in terms of LA parties. It's actually a hot tub where you get economists together. Oh, you've got a hot tub too? Oh, okay. I didn't realize that. So apparently hot tubs are a big thing also in the UK. And again, it's something worth talking about in the cocktail hour because it's actually quite fascinating, but not in the way you think it is. Kathleen, we've got what I would say was the equivalent of an earthquake in Los Angeles from your boss earlier today. Yes, exactly. It's difficult, and yet since you knew that was coming, you actually have something that's even more fascinating for us for this session, because you're the one who has to deal with everyone complaining on a regular basis, and so, you know, from that standpoint, please tell us like what that's like.
Good afternoon. My name is Kathy Bradish, and I'm the Assistant Chief in the International section of DOJ's Antitrust Division. And I just have to give the standard caveat that the views I express here today are my own and should not be attributed to the Antitrust Division. And I will also recognize that I have a very tough act to follow. So I will take the advice of a very wise man and remain humble in my ambitions today. So before joining the DOJ, I spent a decade in private practice as an antitrust lawyer, where a significant part of my practice involved advising clients on how to keep their IP licensing practices consistent with the antitrust laws. In my current position as an enforcer and as someone whose job it is to be aware of how other jurisdictions are articulating how to conduct IP-related antitrust enforcement, my perspective may be somewhat different, but the issues that I see are very much the same. In both contexts, I have found that it is important that the complexity that sometimes surrounds IP, whether that complexity be technological or legal, not obscure the basic principles that have long applied to patent licensing. And I think this is especially the case, given our topic, given the potential global impact of an IP remedy. It is particularly important that the antitrust enforcement be based on sound, economics-based competition policy. So I will use my time today to review some of what we've talked about earlier this morning and at lunchtime. And I just want to reflect on the fact that some of what we heard, most of what we heard at lunch today is deeply rooted in antitrust policy that has guided US antitrust enforcement for many years. I also want to take a moment to think about how those principles, and when we look behind them, what those principles mean for antitrust enforcement, mean for one particular issue, refusals to license, that I see coming up repeatedly as jurisdictions think about how to frame their antitrust enforcement in this area. So, the general principles which guide US antitrust enforcement in this area, as we've heard several times today, are laid out in the antitrust guidelines for the licensing of intellectual property issued jointly by the DOJ and the FTC. And those principles have not changed since the guidelines were first issued in 1995. In fact, the update to the guidelines that occurred at the beginning of this year reiterated those principles. And they are the core principles that have guided US antitrust enforcement for many years and will continue to do so, as you heard in our keynote speech. What are those principles? First, intellectual property must be analyzed using the same general antitrust principles as any form of property. Second, there is no presumption that intellectual property creates market power. And third, intellectual property licensing is generally pro-competitive. As we have already heard today, these principles do not presuppose that there will be no antitrust enforcement or even weak antitrust enforcement when IP is involved. What the guidelines tell us is the exercise of intellectual property rights is neither particularly free from scrutiny under the antitrust laws nor particularly suspect under them. The first principle that we've heard many times today is that intellectual property is at its core property. For antitrust laws to treat IP as something less than property would be to undermine the purpose of IP law in supporting and promoting innovation. This is not to say, as the guidelines recognize, that IP doesn't have special characteristics. As the guidelines point out, one of those characteristics is ease of misappropriation. It's simply easier to misappropriate patented knowledge than it is, for example, to steal a ski slope. The particular characteristics of IP are just simply part of the factual assessment of a potential violation of the antitrust laws under the standard antitrust analysis. So what does it really mean to assert that IP is property? Obviously, that means it confers the ability to exclude, and it means the IP owner has the ability to decide when and if to license its intellectual property to others. Preserving this freedom to license is essential, among other things, to encouraging those developing new technologies to disclose them to others. So what is our takeaway from this principle? While the specific facts of a case always matter, there should not be one kind of analysis for IP and another kind of analysis for other kinds of property. Second, the grant of an intellectual property right does not create a presumption of market power. This has been the US agency's position for years. And the updated version of the guidelines has the benefit of definitive Supreme Court case law. As Ian mentioned earlier this morning, more than a decade ago, the court in Illinois Toolworks versus Independent Inc. agreed unambiguously with a long-held government position. And our guidelines tell us there will often be sufficient actual or potential close substitutes for the IP-protected product, process, or work in question. In sum, just because conduct involves intellectual property licensing, it does not mean we can short-circuit a fact-based market power analysis. Finally, the guidelines recognize that IP licensing is generally pro-competitive. What does that mean? The pro-competitive benefits that we see detailed in the guidelines include engaging in efficient contracting for complementary factors of production, facilitating integration of IP with those factors to reduce costs and to encourage new products, and promoting coordinated development of technologies where one IP cannot be practiced without another. This means for antitrust analysis that any antitrust analysis of an IP licensing arrangement must consider carefully its potential pro-competitive benefits and not begin with the assumption of anti-competitive effect. By working in a way that supports the strong enforceable property rights for IP holders, antitrust enforcement can both protect competition and the incentives for innovation that are embedded in the IP laws. Conversely, when those property rights are compromised and imitators can quickly co-opt the efforts of investors and innovators, the commercial value of the innovation and the incentives to invest are eroded, ultimately to the detriment of consumers. These three principles come together in the case of whether a refusal to license should be an antitrust violation, and whether, by principle of inclusion, whether essential facilities should be an antitrust violation. When an IP holder has a strong market share or its IP is particularly useful to an industry, there may be considerable pressure for an antitrust enforcer to give others access to that IP. That's just the way it is. But finding an antitrust violation simply for those reasons harms incentives to innovate and disadvantages consumers in the long run. Consistent with the core principles it describes, the updated IP guidelines specifically recognize that imposing antitrust liability for a firm's unilateral refusal to assist its competitors may undermine incentives for investment and innovation. And in fact, the Antitrust Division, in its long history in this area, has never found a circumstance in which a unilateral, unconditional refusal to license IP harms competition. As to the specific question regarding the extraterritorial application of, in this area, as Ian noted earlier today, that is specifically addressed in the IP guidelines. The IP guidelines helpfully point to the antitrust guidelines for international enforcement and cooperation, where we find that a lengthy analysis of how comity plays into the prosecutorial discretion exercised by the antitrust agencies. And it's worth, I think, a read for those of you that haven't looked at it in a while, or haven't looked at the updated version of the Antitrust Guidelines for International Enforcement and Cooperation. Key there, it says, in determining whether to investigate or bring an action or to seek particular remedies in a given case, the agencies take into account whether the significant interests of any foreign sovereign will be affected. And I would note that in the further detail that's provided about how a comity analysis is done, it is not limited to conflict of laws or the traditional conflict of laws analysis, but also also notes that beyond conflict of law, in determining whether to investigate or bring an enforcement action, the agencies consider the extent to which a foreign sovereign encourages or discourages certain courses of conduct or leaves parties free to choose among different courses of conduct. So with that, I will await questions and turn it back over to Danny.
Thank you. Much as I found something interesting with regard to Australia, there's something that I found interesting with regard to the Department of Justice, just to show how far it's come. Think back to the 1970s. Some of you might remember, the mustaches or the bell bottoms. I actually want to go back to a very different framework for how the Department of Justice thought about IP, something that we called the 9 no-nos. And it's something that gets referenced. No one seems to recall just how bad things were in terms of the Antitrust Division understanding of IP. And I wonder if you could give just a little bit, since we have people from around the world, just a little bit of historical context of what was then versus what is now. So polyester suits definitely out, and the ruffled shirts that went with it, right, out, and that's a good thing. And so much the same way, there was a very different vision, and it also seemed to coincide at a time that the United States wasn't innovating relative to Japan, Germany, elsewhere, and all of a sudden we started to appreciate IP. I wonder if you could just give just a little bit of background, particularly we have some students still left, and they might not know this history, that how important where we are is relative to where we were.
Yeah. Well, one of the advantages we have in the U.S. at both the FTC and DOJ is over 100 years of experience with the antitrust laws, which includes a lot of factual, case-specific, digging into the weeds, figuring out what is really going on behind the scenes over the course, and we have collective knowledge from that, and the collective knowledge that comes from having our theories tested over and over again in front of U.S. courts, which can be very demanding. So I think the IP situation is an example of that. Our antitrust laws have evolved. Our policies have evolved. We've become much more economics-based than we were. We learn from our mistakes and from our experiences. And I think when you look at IP, that is particularly the case. There were a prescriptive list of 9 no-nos at one point in time. But experience and economics did not bear them out. And it was really the influence of what will be the effects, and a more comprehensive view of what benefits consumers. We've come to learn, as you hear both from what the FTC said this morning and from what Assistant Attorney General Del Rahim said today, we've learned to appreciate the importance of innovation and the importance that that has for consumers, not just for the companies that are innovating. So I think when you see us moving from a prescriptive list, no, don't do this, no, don't do that, no, don't do something else, to a much more flexible framework, and a framework that is built on evidence and the facts of the case, I think you see the best of the evolution of U.S. antitrust law.
And I think it's helpful, and there's just one thing that you said that I really want to articulate, which is that the U.S. system is not perfect, and there have been many mistakes made along the way. But we're, and so maybe one broader lesson to other jurisdictions is please don't make the same mistakes. You don't need to.
Yes, we've been through it.
Yes, yes. So we have what we call a natural experiment. Don't do what we did wrong. I want to thank our panelists very much for this last panel. I think it was really very informative about a number of fundamental issues that have recently come up in various jurisdictions. Let's once again thank them. I guess we have Dean Guzman in the back. I'll quickly introduce him by saying a real innovator, both in terms of his scholarship, where he was really one of the first to spend significant time thinking about issues of comity and extraterritoriality and antitrust, and also thinking about global governance type issues. These issues, obviously, we saw have come up in a number of the panels. And then also an innovator as a dean, including the center's concentrations for both JD and LLM students in transnational law and business. I believe perhaps the first school in the United States to do.
Let's say yes. First and the best.
Yes.
So I just want to thank everyone who's participated. I aspire to have my closing remarks be shorter, both than that introduction and than my opening remarks. So thank you all for being here. I hope the conference proved to be fruitful and enlightening. The speakers, we're so appreciative for your being here and adding to this intellectual exchange. I hope you will all be able to stay for the reception and that we will see you again at a future event. Thank you.